You say the situations in which these would arise will be rare and unusual. Why in the world would that be the case? You've got somebody sitting in jail and they got 20 more years to look at, and you go in and say, gosh, I think there's like a 1% chance, you might be able to get out. The prisoner is going to say, oh, okay, it's only 1%. Let's forget about it. Every lawyer would bring these claims. And some judges are going to grant them and some are not going to grant them. And I'm not sure this factor is not something that Congress took into account. And it does seem that this is, well, why would this remain rare?
Certainly, Your Honor. And the reason it would be rare is precisely because of the habeas statute, that the defendant did have an opportunity, potentially, to raise these issues on habeas. Maybe he procedurally defaulted. He will then have to show why he procedurally defaulted. What were the circumstances surrounding that? Because merely procedurally defaulting on a potentially meritorious claim normally would not be found to be compelling.
Did the meaning of extraordinary and compelling reasons change in 2018 when Congress enacted the First Step Act?
That's not our position. Our position is that it has meant the same thing, and that would be the dictionary definitions of extraordinary and compelling, since 1984.
Well, until 2018, only the director of the Bureau of Prisons could invoke the statute, right?
That's correct, Your Honor.
Is it plausible that Congress intended for the director of the Bureau of Prisons to make motions for sentencing reduction based on an assessment of the strength of the evidence or any factor that has to do with the trial proceedings or the sentence that was imposed?
I do believe so, that it was at least possible, Your Honor, as referring back to the cases that Justice Sotomayor discussed.
Yeah, they're two isolated cases, but doesn't that seem to be far outside of the area of the director of the Bureau of Prisons' expertise?
Well, there could be
and responsibility.
That's certainly true, Your Honor, but I would suggest that the other agency that is involved in 3582 is the Sentencing Commission, and there was a delegation to the Sentencing Commission, whose expertise, of course, goes far beyond the Bureau of Prisons to set up guidelines. The Congress did not delegate that task to the BOP.
And why would our consideration be limited necessarily to what was in the purview of the BOP? I understand that there was an amendment that allowed the statute or allowed these motions to be brought by a defendant and essentially bypassed the BOP. So I'm wondering if that doesn't indicate Congress's intent to allow for the consideration of factors that the BOP either wasn't able to or wasn't considering.
Well, certainly, yes. Justice Jackson, we do agree that when Congress amended the statute, the reason it did so, and it was quite explicit about this, was to allow more circumstances to be raised. It's our position it's not because the BOP was not able by law to do so, but that the BOP was not bringing enough of these sorts of motions.